Good day, and welcome to Epstein Becker Green's webinar, Privacy and Security Crash Course, Questions when Dealing with Employees. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You are welcome to submit questions directly to the presenters following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have 2 fantastic speakers today from the firm's Washington, D.C. office. Solander, who is a member of the firm in the Healthcare and Life Sciences practice, and Nathaniel, who is a member of the firm in the Labor and Employment practice. At this time, I'd like to turn the webinar over to Nathaniel.
Welcome, everyone, and thanks for joining us. I'd like to start today by asking our audience to think of all the confidential and highly sensitive data that's digital these days, trade secrets, personnel information, and patient records, and now consider how easily a rogue employee can walk out the door with that information if the proper precautions aren't put in place. Data that could cripple your organization or lead to identity theft of your employees or customers can be saved to a thumb drive or simply emailed out of the organization. So as Adam and I were preparing for this presentation, we were talking about the first step to combating digital data theft, and that's to put into place the right policies and procedures. The first thing that you want to do is in any employment agreements that you might enter into with your employees, and particularly those employees with access to confidential, proprietary, or other sensitive data, should provide you with the right to monitor their electronic presence on your network, which would include the right to inspect all electronic devices, including laptops or mobile phones that they might use, and anything else that they might use during the course of their employment. More broadly, make sure that you have the right technology policies in place to prevent data theft, and those include a policy or multiple policies regarding internet usage at work, use of computers, tablets, mobile phones that would be used to access company servers and data, and the use of email for business purposes. These days, of course, bring your own device policies are increasingly necessary because most companies are allowing employees to access company email and sometimes the servers from outside of the office. And the hallmark of any of these policies are the right, where necessary, of the employer to monitor an employee's use of the internet, email, and access to company data. One of the questions we received before this webinar was whether the company can single out an employee to monitor his or her emails if they suspect that that person is doing something nefarious with the data. And generally, the answer to that question is yes, if you have one of these policies in place, because they'll expressly permit the monitoring of emails, and they put the employees on notice of that monitoring. And so as we'll discuss later, if you do have these policies in place, you don't run afoul of federal law, and you likely head off any state law claims for invasion of privacy, so they're very important. The next thing you want to do is make sure you have a data retention policy in place that conforms to the applicable laws. You want to be deleting information on the system whenever possible and necessary, so that to the extent that there is a data breach, any data will be contained. It's also very important to have procedures in place for new and departing employees so that they know and understand the prohibitions from the use of company data outside the workplace, and that departing employees return any confidential information and any electronic devices that they have in their possession. And you also want to make sure that your IT department properly sets up those devices so that they're monitored and then appropriately decommissioned upon the employee's departure. So to do all of this, obviously you have to have the appropriate technology in place, and Adam will talk about that in a minute. And then conduct periodic employee training and have security reminders. These two things go hand in hand. Just like having proper procedures in place, it's important to make sure that your employees know the rules and that they're reminded of them. And these things can be as simple as having a notice on the login screen for every employee reminding them of the monitoring technology in place, or a brief online security tutorial that has to be electronically signed every few months or at least each year. And finally, as with any policy that's implemented in the workplace, you have to implement appropriate discipline when any of these policies are violated. And now I'll turn it over to Adam to talk about technology.
Wonderful. Thank you so much. And one thing that struck me as I was putting together these slides is that almost every major data breach that we've had this year has involved some element of employees either doing the wrong thing or being tricked into doing the wrong thing. So from an employer perspective, one of the most important things that you can do is put in place systems so we're not fully reliant on our employees to do the right thing and protect data the way we'd want them to protect data. When I think about this, there's sort of three buckets that I would loop this in. And the first is eliminate the ability of employees to, steal data or make mistakes that could lead to a disclosure of data. One of the things that really is an issue of controversy, and there's a lot of debate about it, is employee monitoring software. There's software out there now that employers can use to really monitor the activity of their employees, both inside and outside of work, which is what really creates the controversy. And that software can help detect when an employee, may be leaving the organization, trying to steal IP secrets, or simply making mistakes and not protecting data the way you would want. Employers at this point, I think one of the most important controls they can put in place if they don't want to go all the way to employee monitoring software is email filtering. Make sure that you have a good handle of the information leaving your organization through email. It's what employees use. If employees are going to misappropriate data, it's the avenue that they'll most likely use. In terms of also eliminating the opportunity for misuse of data, it's important from a technical standpoint that you have role-based access in place and that you're actively monitoring your groups to make sure employees don't have access to data that they don't need to do their job. This is something we see over and over and over again where group policy settings are put in place, people have access only to the data they need, but those rules start eroding over time and people have access to way more information than they need. In line with that is what Nathaniel talked about a little bit earlier, which is a data destruction policy. Anytime there isn't a need for data, you want to get that out of your organization and out of, especially legacy systems, places that may not be actively monitored for security. Finally, one of the things that we've encountered this year several times is paper-sensitive information. Paper is very hard to track. It walks out the door most of the time when sensitive paper is lost. Individuals will simply think that they by accident throw it away and may not go to management and tell them they've lost the data. The same thing holds true if you're worried about employees taking trade secrets. So printing out information, that kind of thing is something you really want to get a hold of. If you have sensitive data, employment records, employment histories, all of that stuff should be kept under lock and key for as long as possible and always, under camera, etc. You also want to be as foolproof as possible. This means getting rid of a lot of the opportunity for people to either misappropriate or lose data. One of the most important controls here is locking down USB ports. About half of the data breaches that we respond to is simply somebody downloaded data they shouldn't have to a USB drive, lost that USB drive, and then told company management. So that is a very simple way in which you can really stop a lot of the information from leaving your organization. Anytime you have a laptop computer or a hard drive, you want to make sure that you are encrypting that. One other area that falls beneath the radar in terms of sensitive information are local repositories of sensitive information. These are your share drives that are out there that people are saving information to. A lot of times those share drives don't have the same security controls that the intended repositories do. So they're not being logged. You don't have the same group policy settings to make sure only people who need that information get that information, and it's sort of the Wild West. That's where a lot of sensitive information is taken. So we recommend that you scan those drives, figure out what's out there, and eliminate that information if it's no longer necessary. The other thing is there's a lot of ways to share information now through open source solutions, Dropbox, iCloud, all of that. None of that stuff really has a place in a corporate environment. That is something that should really be shut down. You want information to flow through, email that you're filtering or secure file transfers that you can control the information that's out there. You don't want to have separate avenues where people can use to get information outside of the organization. So be as foolproof as possible and eliminate the opportunity to steal that information. The other thing that we hear over and over when we respond to these incidents, when we start interviewing employees, is that they say, you know, the information was probably taken because we're not monitored. So make sure that somebody is at the wheel steering the ship, cameras, audits, you know, Nathaniel talked about education. Make sure that the employees know that the company is actively monitoring their data and taking steps to prevent loss. Moving on to the next slide, you know, I think this is something that should obviously be reflected in policies, but what do you do if your employee has taken confidential information? First step that should be in the slides is have a policy that addresses this, but you should immediately investigate the scope and the nature of the data breach. That includes both internal and external resources from outside counsel, forensics investigators, et cetera. Make sure that when you do this in a formal way. So if you're imaging, for example, a laptop to figure out what may have been downloaded to that machine, do it in a way that is forensically sound that can be used as evidence in court later. Let the individual know that you know that information has been taken. Send a cease and desist letter and formulate a plan to really get this information back. You know, contact police. This is something where a crime has occurred and the police are appropriate to be notified. And finally, you can always file a civil suit and seek injunctive relief to get this information back. All of this is very important to showing employees that, you know, may think of taking information in the future, that the company is serious about this and will do everything it can to get their information back and protect information. I know Nathaniel has a couple of more things to add to this, so I'll turn it to him for the next slide.
A lot of times, this comes up in the context of self-help discovery by an employee seeking to bolster their lawsuit. It might be a discrimination or other type of lawsuit against the company. So what can you do if you learn about this a potential data breach in the context of a litigation? Well, courts have at times, and particularly with respect to whistleblower claims, have permitted an employee to preserve or take certain documents that might be directly relevant to their claims, but particularly where they've gone further than that and have taken documents that are unrelated to the litigation or have essentially gone on a fishing expedition. Certainly, you may seek sanctions, including dismissal of the complaint in certain jurisdictions. You could consider a counterclaim for fraud, unclean hands, or something similar. And if the plaintiff's counsel has been advising his client or her client on taking documents, that counsel potentially might be disqualified if the advice goes too far. And outside of the litigation, of course, if you have a current employee pursuing litigation, that conduct might support discipline or termination of the individual. And depending on the nature of the documents, criminal claims might be pursued, particularly if there is a potential for identity theft if other employees' personnel information is taken. We could go to the next slide.
Great, thank you, Nathaniel. And now we're going to shift gears a little bit. We've talked mostly about what to do and how to prevent employees from stealing sensitive information. One thing that we didn't want to miss in this webinar, even though it's a short webinar, is the steps you should be taking to protect employee-sensitive information. So employment records, group health plan information, all of that. There are a number of laws out there that will protect this information and require that employers protect this information in a certain standard. It may be encrypted, et cetera. There's a couple of different buckets that you want to look at. One is state law. Most states have passed data privacy laws that govern the way you handle sensitive information. If this is group health plan information or consumer information, you know, HIPAA or the FTC rules would apply as well. This all becomes really important as some of you may be aware, Sony Pictures, when they experienced the data breach from the North Korean hackers, lost a lot of their employees' sensitive information. Those employees turned around and sued the organization for not taking reasonable steps to protect that information. We don't have time to go into that case in detail, but I think it really does highlight a new frontier for plaintiff's litigation, is as an employer, if you're not protecting your employee data the same way that you would protect the sensitive data from your business, that's certainly a liability and an opportunity for some exposure out there. Nathaniel?
Thanks, Adam. And again, state law occasionally provides a common law claim for invasion of privacy or grants employees privacy rights that federal law might not grant them. So you want to be aware of that. And you also want to be aware of the type of email you are monitoring, whether it's an employee's work account or personal account, because there might be differences in how court treats your monitoring, even if the personal email account is being accessed over a company server. So you want to be aware of how state law treats those invasions. We talked about whistleblower protections earlier. An employee might be within his or her rights to take certain data if they believe they have a whistleblower protection claim. And certainly be aware of the obligations that you have contractually with an individual or under collective bargaining agreements that might limit your right to monitor and review communications of that individual or certain bargaining unit members. And certainly for public employers, the Fourth Amendment prohibition against unreasonable searches and seizures always comes into play. In 2010, the Supreme Court in a case called City of Ontario v. Kwan said that government employers may generally review workers' emails and texts if they have a reasonable work-related grounds to do so. But bottom line, with respect to all of these potential claims and the privacy rights that might be granted to employees, it's always best to have the protections of a workplace policy in place and to have a business reason for reviewing emails or internet history or an employee's electronic devices before conducting a search. I think that wraps up our quick 15-minute webinar for today. Thank you for joining us.
Thank you for joining us. This concludes today's webinar. If you have any questions, please feel free to contact today's speakers directly. Their contact information is displayed. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you.